We're going to start with number 191 and 192. Counsel?
Good afternoon, Your Honors. First, I'd like to reserve 2 minutes for rebuttal time.
2 minutes. You're on. Go ahead.
Okay. May it please the Court, my name is Robin Nichinsky. I represent appellants Luciano, Rosario, and Marcos Llibre. As this Court and the United States Supreme Court have held, no defendant should lose his fundamental right to appeal due to ineffective assistance of counsel. When that happens...
Counsel, what's the difference between the two cases?
Well,
I mean, the meaningful difference. We know the two different
right. Well, both of the defendants made credible and sufficient allegations pursuant to Cyville that they were...
Tell us what the difference in the two scenarios are.
Okay. In the case of Mr. Rosario, he was not informed of the right to appeal at all. He had a 2-page plea and sentence. He said nothing at all. Nothing was said to him. He was asked nothing.
This was the second time that this was the second time he was going to be allocated?
Was aborted because he was unable to allocute. He was confused.
The first time, right?
The first time he gave multiple.
So what happened on the second time?
The second time, they didn't let him talk at all. He said nothing.
Who talked?
The court talked to the lawyer.
And what did the lawyer say?
The lawyer said he's going to allocute to the same thing as before, or he's going to plead guilty. He didn't allocute.
Did he ask if he waived? Did the judge ask the lawyer?
The judge did not ask Mr. Rosario anything. He asked the lawyer.
The lawyer. What did the lawyer say? He asked if the defendant waived, right?
The lawyer said, the court said to the lawyer, do you waive 3 things at once? Allocution, the right to appeal, a waiver of the right to appeal, and a third thing, I guess, an SCI, something related to the SCI.
And what was in writing? Was there anything in writing?
Nothing in writing.
And what did the attorney for the original attorney say about what the defendant had been told about appeal?
Nothing. I mean, she said he waives his right to appeal as part of that listing of 3 things.
No, but
there was
wasn't
nothing
there
on the record.
Something about the original attorney in Rosario said that, well, I normally tell them about the right to appeal?
Oh, you're saying that afterwards, that she said it was her practice?
Yes.
Actually, she told her boss that it was her practice.
Yeah, I didn't think there was any response from her at all.
No, she said she didn't remember the case at all.
But that's her normal practice.
And she, according to her boss, she didn't tell this to me. She told her boss it's normally her practice. I would say that she has a responsibility to write that down. Her file didn't indicate anything.
Okay, for the time being, we're just getting the difference. All right, that's Rosario.
Yes.
What about Llibre? What's the difference? What happened there?
Mr. Llibre was misadvised about the right to appeal. The appellate process was not explained to him. He wasn't told he had 30 days to file the notice of appeal. And what he was told about waiver was improper and was misleading and invalid.
But he signed certain things, right?
He signed a waiver, but the issue that he has in this case is an issue that survived the waiver. So even if you found there was a valid waiver, which I submit was not a valid waiver.
Let's get the facts first. He signed the waiver, right?
He signed in court.
On the form it was checked.
In court, he signed a waiver.
And on the form in court, what did it say
In court, the judge orally said, well, you know, you're not really, there's not much to waive here anyway. It's the same court that also told him that he would have immigration consequences if he was in the country not legally, which this court remitted on in the Peque case, the defendant in Peque. That was the only case in Peque that was remitted. It was the same judge giving the same language on immigration consequences.
So he's checked that he signed the waiver, and he's checked that he's waived, and he signed the waiver in that case, right? And what about consultation?
No consultation.
Didn't the written waiver say that he had consulted with his attorney?
The written waiver said he had discussed it with his attorney. He said he had discussed it with the attorney also verbally, but the attorney was standing there and let the court misinform him when the court said, well, you really don't have any issues to raise, and the court said, you know, if you're you only have immigration consequences if you're in the country not legally. So I would say, I don't know what kind of discussion that was, but under Flores-Ortega, because particularly, I think this is really critical, the issue that arose in this case arose during the plea itself, and it's when the court misinformed the defendant about the immigration consequences.
Did he move to vacate the plea then?
Did he move to vacate? No, he didn't know that it was misinformation, Your Honor. Nobody told him.
But I mean, well, is there any time limit in which to move to vacate the plea? In other words, if he at some point said, "Whoa," you know.
Well, he could have moved to vacate the plea if his attorney had consulted with him, if his attorney had spoke up.
Could he now?
But nobody did.
Is there a time limit on 440s? I mean, a motion to vacate the plea?
I don't believe so.
So he could do it today?
Under 440?
Yeah,
Well, his 440 has been denied.
that's my point. So that's not an issue. And what you're asking for is the right to appeal. That's all.
That's all.
Not to have anything reversed or anything else. You just want to be able to file an appeal, and the grounds for that appeal will be what? The same thing that you brought the 440 on that was denied?
Well, the 440 found that, said that the quorum showed he had ineffective assistance, but the quorum didn't really find anything.
Well, there wasn't any opinion on
the quorum was just denied.
But here, let's take a step back. The issue really before us today isn't the validity of the plaintiff's claims. It's really a question of whether or not the Cyville rules apply, because it seemed to me in Cyville, in that case, in trial counsel there essentially admitted ineffective assistance of counsel by an affidavit. You don't meet the standard of Cyville in either case here. Excuse me. From my review of the record is that I don't see anything that said that where you got an affidavit from any attorney saying, as you did in Cyville, that that yes, I didn't tell counsel about this. What you only have is an affidavit from the person directly involved, the defendants in this case.
Your Honor,
Is that
my
fair?
response,
Yeah.
my response to that is that that was the particular situation in Cyville, but Cyville, and in particular also Roe versus Flores-Ortega, stand for the proposition that
let's
you
stay with
cannot
New York
lose a
cases a
constitutional right.
Go ahead. Finish your point.
You can't lose your constitutional right to appeal because of ineffective assistance of counsel. And under Cyville, there has to be a remedy. And I would argue the situation in Cyville is a in Cyville, the defendants knew they had the right to appeal. They were savvy enough to say, let me file a notice for me. We have here.
Let's assume Cyville applies. Does the defendant have to, what kind of showing does the defendant have to make? Is it enough just to say with no support that I wasn't informed? Or
No, Your Honor.
Does the defendant, for example, have to then seek to assert his appellate rights with due diligence after he learns of his rights? And if that's the case, do we have anything in this record at all that tells us whether he did that?
Well, Your Honor, Cyville and Andrews set out certain criteria, and the Backert case, which also talked about quorum nobis and said this Court has the right to set that out. You could set out something similar to 440-30, where, and I think we did here, they made credible allegations, both defendants, that they were not told or misled, that they would have appealed, that they didn't file under 460-30 because they didn't know, and they are more in need of counsel than the defendants in Cyville. The defendants in Cyville knew they had a right to appeal. Here they didn't because they didn't have counsel. They were first offenders. They were immigrants.
Didn't we say that Cyville was going to be a rare case?
Well, it will be relatively rare here. Normally,
How would that be if any defendant where it's not explicitly shown on the record that they were, you know, exactly what they were told about the right to appeal, or, you know, there's something in a file or whatever, all they have to do is make this allegation at any time? Is that the rule?
well, Your Honor, it's not just making an allegation. So, for example, here, Mr. Llibre, normally, judges say something on the record about the right to appeal. Very often, the clerk will hand a notice about the right to appeal. In Mr. Libre's case, they actually crossed it off on the worksheet.
But we have a record in Llibre that shows that he signed this very comprehensive waiver of the right to appeal. Whether it's valid or not is another question. But but
No,
it certainly indicates that he knew something about his right to appeal.
But that's critical, Your Honor. He didn't make a knowing waiver.
I don't
We're
understand.
not talking about waiver. We're talking about whether he knew about his right, not
But
whether
he
waived
didn't
it.
know about his right to appeal. He was never told you have 30 days to file a notice to appeal. He was never given that sheet that most judges give that tell you about the right to appeal and how you can go about the right to appeal.
The problem is here, it seems that you want us to say 460-30 doesn't apply. Cyville was supposed to be a rare circumstance, and it was so rare because their counsel said, yes, I didn't tell him. Here, counsel is not saying, yes, I didn't tell him. And so we have to, so then we're only relying on the person who directly benefits from our decision. And if there's no objective proof or proof that contravenes or shows definitively ineffective assistance of counsel in a case that you argue that the defendant was wholly unaware. I think
Yes,
that's the standard that you're asking us to adopt here. And what I'm wondering is if we do that, does that shift the burden from you, not from you, but from the defendant to the people on a writ of error?
Well, Your Honor, you can't, when you've been denied your constitutional right to counsel, you can't say you can only have it when the DA is going to admit.
Yeah, but wait a minute.
No,
I mean, you gotta-
that's not what I'm saying at all. And
That standard is too high.
Wait, I mean,
In fairness.
it was 6 years.
Yes, Your Honor.
And a written waiver, and you're saying, oh, well, look at, everybody, just violated this man's
But-
constitutional rights, right and left, and this is an outrage, and this is why we have to go beyond the 30, go beyond the 460-30, and do a writ of error coram nobis, which we've done twice.
Well, Your Honor, the reason that it was so long is he wasn't told that he had the right to appeal. He has to prove that he wasn't told that he had the right to appeal.
we
He
don't
has
know
to
that.
prove that he would have appealed.
I just want to go back to the point on,
Under Flores Ortega,
I just want to go back to.
that's what he has to show as well, that he had issues, that he could have appealed, that a rational defendant would have wanted to appeal. He made all those showings in this case. And under those circumstances where he proves he had ineffective assistance of counsel.
Just the last point. It's really what I'm trying to get. I'm trying to see. The problem I have with it is I can see the equities of it. The problem I have is with the burden of proof and whose responsibility is to prove it here. And it seems that the argument that you're presenting us with is that the burden is being shifted from the person making the application to the people. That's really what I want you to address.
Well, I would say no more so, Your Honor, than we have under CPL 440. And looking at CPL 440-30, when you look at the criteria there for when you can successfully bring a motion or when a court may deny a motion, if it's based only upon the defendant's claims and there is no evidence to support it and there's no reasonable possibility to believe it, you can deny it. And you can deny a coram nobis under those circumstances as well. It is a high standard. It should be an unusual, but you shouldn't deny the constitutional right just for that reason.
You'll have your rebuttal. Thanks, Ken.
Thank you.
Thank you.
Good afternoon. David Johnson for the people. Your Honor.
On Rosario, right?
On Rosario, yes, Your Honor.
So what happened in Rosario? The first attorney really could not say that she actually warned him or told him. The first allocution didn't come off. Is it so evident that he's had all his rights here, that this was knowing?
I think so, yes, Your Honor, because
Why?
if we look at the first plea proceeding, the court made it very clear that this plea could result in his exclusion from the United States. Counsel indicated that his client understood, or her client understood that.
And he said, really, that's going to be a problem? Gee, that's a problem. And the judge said, okay, we're not doing it. What happened in the second one that changed, that we can be assured that he knew what was going on, the defendant?
Well, in the second plea proceeding, it was a fairly abbreviated procedure, but I think that's why we have to.
Spoke only the lawyer for the defendant, right?
Yes, Your Honor.
And the lawyer said he waives.
Yes, the lawyer said that he waives formal allocution, prosecution by information, and the right to appeal.
Did we have anything else?
Not from that particular date, but again, going back to the first day, because these only took place a few weeks apart. On the first day, the court did speak with the defendant.
That cuts both ways. On the first case, the judge said, I'm not taking this. without him knowing what's going on.
But before that took place, the court did speak directly with the defendant through the interpreter, and the court explained, if you plead guilty, you give up your right to a trial, to have the people prove their burden.
So now, in between, your surmise or your contention is that in between, the lawyer explained it to him again or whatever, and he said, okay, I'll waive, and that's enough that when the attorney was asked, he said, yeah, he waives. That's it? Good enough?
Yes, because again, at the first time, not to belabor the point, but when the court said, okay, I'm not going to take this plea, the defendant interjected and said, no, I want to go forward. The record is very clear that this defendant just wanted to move on with his life. He wanted to accept the plea because, again, as counsel noted at the first plea proceeding,
you would expect that he would not want to be deported as a result of his plea, right?
Well, he also didn't want to go to jail for up to a year. He was charged with 3 misdemeanors, 3 Class A misdemeanors. So he could have gone to jail for a year and still been subject to deportation. I think it's very clear that this defendant just wanted to take the minimal incarceration.
And be deported and go.
Excuse me, Your Honor?
And be deported. Because if he knew what's going on, he knows he's probably going to be deported, right?
Well, maybe not. We're now 5 years on, and this defendant is still in this country.
What I'm wondering, though, why limit quorum nobis relief only to situations where a defendant has affirmatively requested it, as in Cyville, where there's been an affirmative affidavit? I mean, what policy reason would be for us to limit it in this case if it seems to be clear inequity?
Well, Your Honor, I wouldn't say that because I think, as our brief makes clear, we are fine with an exception in circumstances such as like this as a general proposition. But as I think all of Your Honors made quite clear, there has to be credible allegations from the defendant, which I don't think we have here, because otherwise we're talking about unleashing the floodgates. As I think my colleague from Manhattan noted in her brief.
What would have been credible allegations?
Well, first, it would have been helpful if we had an affidavit from the attorney. While I know that the defendant spoke with legal aid and they declined to provide such an affidavit.
Oh, wait a minute. I don't think the defendant spoke to legal aid. I noticed that, and I think it was an attorney who spoke to legal aid who said, we're not turning it over. Because I always thought if that were me, I'd say, well, then the defendant clearly can go get her own file, or his own file in this case. And so if he had asked, obviously they'd have to give him his file, and they'd have to, I assume if he wanted an affidavit, get one, and that wasn't done in this case.
Well, I can't speak to what could have happened if the defendant had asked for the affidavit. I do believe it was defense counsel. But, again, legal aid didn't provide an affidavit. The attorney said it was our general policy to advise as to the right to appeal.
Now, I'm giving you a softball. I'm agreeing with you. I'm saying I got the point that, somebody calls up and says, I want to see a file, they're not going to show it. But if the defendant calls up and says, I'm the person you represented, I want to see my file because I'm trying to get a 460-30 or a writ, I would think they would be compelled to, and if they didn't, I would think a subpoena would work.
I would think so, Your Honor.
But the point is, I thought your point was that it's not the attorney who indicates what she did or didn't do. It's the supervisor saying, I am informed by her that this is her usual practice. And you're saying that's the problem?
I'm saying
that's not a credible allegation on his part, relying on that statement?
Well, I'm saying that's one of the problems. One of the other problems is that the defendant's affidavit said that he wanted to contest this case and go to trial. And as I said earlier, I think the record is quite clear that that's not the case. And if we're going to analogize to 440-10 and 440-30, I think that an unsubstantiated allegation has to have some contextual support.
Counsel, is this a stronger case or a weaker case than Andrews?
I would say it's on all fours with Andrews in terms of the credible allegations that were brought, and that's why the defendant's allegations here were insufficient. And so I see that my time is up. I would just ask that this Court affirm the Court's order. Thank you.
Should I respond to that 1 minute and then to
I think you can just answer them both unless you want to. I mean, I think it's hard. How many minutes did you keep? 2. You want to do 1 and 1, or do you want to just do 2 at the end?
would you mind if I could?
Go ahead.
Thank you. Just factually, we got the trial file in this case, and there was no indication that there was any discussion about the right to appeal in the file. what I was talking about with the phone call was
Hold on a minute. Maybe I misread the record, but I thought someone had tried to contact, as counsel was saying, and they weren't going to cooperate. They said, we're not, you know.
Correct. Well, I got the trial file,
Is
and
it
then I
is it in the
called the
record?
lawyer.
Is it in the record,
Yes.
the trial file?
No.
Oh.
But my allegations about that there was nothing in the trial file are in the record. There was nothing there referring to this. Then I called her, and she wouldn't speak to me about the case. She had legal aid counsel call me back.
Well, that's what I mean.
And say it was her
Couldn't the
practice.
defendant contact his former lawyer and say, you've got to talk to my present lawyer because I'm trying to get something done here?
She would not have done that, Your Honor.
Who
It's
would
the
not have done
policy-
what?
It's the policy of the Legal Aid Society to not speak to us about potential ineffective assistance of
No.
counsel
I'm talking about the
cases.
defendant. I mean, if I'm the defendant and I go and say, you were my former lawyer, I'm about to be executed, I got to have you talk to my new lawyers so they don't throw the switch on me by midnight tonight. I would think they would talk. I would think they would talk under any circumstance where a defendant comes and says, you represented me and I need your help now on this post-conviction
Your Honor,
motion.
that is not the policy of the Legal Aid Society.
That is not what?
Not the policy of the Legal Aid Society.
They will ignore their own
In an
client.
ineffective assistance of counsel case, they will not speak to you. If you subpoena them, they will come to a hearing, but they will not talk to you. This,
Okay, counsel.
I just
Counsel,
also...
okay, you'll have your 1 minute on the other case.
Okay.
Counsel. Llibre, go ahead.
Good afternoon. Hope Kornstein for Respondent, People of the State of New York, on People versus Llibre. In this case, the record is pretty clear that defendant knew his appellate rights. He knowingly, intelligently, and voluntarily waived those rights, and he did so for a really good reason. He got a really, really beneficial plea deal, and a plea deal that reflected in all ways a very immigration-conscious strategy. And the reason that he didn't appeal his conviction is for the simple reason that he had no incentive to do so.
So are you arguing that that's the civil exception to 46030 would never apply in a situation such as this where a defendant claims that he was not informed of his appellate rights?
Well, I
Or are
think
you just saying that it doesn't apply in
it doesn't
this
apply
case?
here because
Because
defendant's claims that he was not informed of his appellate rights are belied by the record.
Is
Because
that his waiver?
Yeah,
Is that
the
the written
waiver, the
waiver?
oral colloquy as well as the written waiver. And the oral colloquy
Is this typical for these kinds of written waivers to have an attorney's signature on it?
It is not atypical. I've seen many where the attorney does sign. I've seen many where the attorney and defendant sign in open court together. And, I can't speak to what's typical. In my experience, it's not uncommon. And the oral colloquy is also not uncommon. The prosecutor noted that for the record, defendant is filling out the waiver of appeal. The court said, have you specifically discussed that with Mr. Berman, his attorney? Defendant said yes. The court said, you are agreeing to do that. The defendant said yes. The court said, we haven't done pretrial hearings, so you're not waiving much, but you're waiving your right to appeal. Do you understand? Defendant says yes. And defense counsel then notes that defendant was executing the written waiver of appeal. And the written waiver of appeal also says, I hereby waive my right to appeal from this judgment of conviction. The waiver doesn't apply to 4 following issues, including the voluntariness of the waiver. However, I understand and agree that I hereby give up all other appellate claims, execute and sign voluntarily and knowingly. After being advised by the court and after consulting with my attorney, I have had a full opportunity to discuss these matters with my attorney, and any questions I may have been answered to my satisfaction. I've agreed to give up my appellate rights because I'm receiving a favorable plea and sentence
So your
agreement.
position, if he then signs an affidavit saying that my attorney did not give me my appellate rights, that would be an insufficient record, correct?
Yes, I
Okay.
think it would be.
If his attorney says I did not inform him about his right to appeal, would that be a sufficient record? Is that what's wrong with this case? If his own attorney, that's why I asked you about the signature on that waiver.
I think what's wrong with the case is that there is no support for defendant's allegations whatsoever. His attorney wasn't actually asked about appellate rights, and so his attorney didn't have an opportunity to state what his practices are, what notations may or may not have been on the file. The other problem is that 5 or 6 years passed, and so one can hardly blame the attorney for not recalling a case that occurred 5 or 6 years ago. I mean,
Although he might have that copy of the waiver with his signature on it.
He did have the copy of the waiver with the signature in his file.
Might refresh
correct.
his recollection, but let's go with my hypothetical. If an attorney, same facts, but the attorney actually does sign an affidavit saying, I know what the record shows, but I absolutely recall not informing him of his rights to an appeal.
It's difficult to say because the attorney
Would he at least be
signed-
entitled to a hearing?
I think it isn't out of the question that he might be entitled to a hearing, but it's hard to understand how an attorney would do such a thing because as an officer of the court, he signed this document in open court saying, you know, co-signing that his client was informed of all of the rights
I
under
think
the
Judge,
waiver.
Judge Rivera is talking about a different case, a hypothetical case where you don't have that.
But where the waiver is signed. Is that your
Waiver
hypothetical?
is signed, yes.
So then there's sort of this contradiction, and maybe that would actually invite a hearing, because on the one hand, as an officer of the court, he signed a waiver saying one thing, and on the other hand, he's signing an affirmation saying another thing.
You know,
So-
I think that all 4 appellate divisions have a rule now that require an attorney to inform a defendant of the right to appeal.
Yes, that's-
Why wouldn't we just make that the standard and say, from now on, it's got to be on the record, you got to inform the right to appeal, boom, period, that should be the rule. And if it's not on the record, then you have a right to appeal.
Well, I think if you look at Flores-Ortega, the Supreme Court at least talks about times when it isn't rational for a defendant to want to go forth with an appeal, and there's no reasonable demonstration that he wishes to appeal, and under those circumstances, the attorney wouldn't
I was kind of
be
thinking differently. I was
obliged.
thinking sometimes, you're right about that, but there's also, of course, the court could inform somebody of a right to appeal. So it wouldn't have to be an absolute that an attorney would have to do it. So a per se rule might not apply, but the face of the record may have to show that a defendant was informed in some form, whether an attorney or, as the department to say, or the court itself.
Well, I think the face of our record actually does show that he was
It's pretty good on Llibre, but it's not quite the same in Rosario, so, okay.
Okay, counsel, thanks.
Thank you very much.
Counsel Roboto.
Your Honor, even if you have a waiver of the right to appeal, the waiver does not waive everything. It doesn't waive an involuntary plea, which is what we had in these cases.
Then you should be moving to vacate the plea. That's why I asked you before. I
Well-
mean, at 440 would take care of the plea. All you're asking for now is the right to appeal on the record that is, that will ultimately be before an appellate division. So you're saying, just let me file a notice of appeal. And what we've done from Montgomery to 460-30 is say, fine, you got a year and 30 days to do that. So that after, once you take the plea, you expect your appeal is going to be filed within 30. If it's not, you call somebody and say, what's going on with my appeal? If they don't do it within 30 days, we say, well, at least do it within a year. That's not a burden on somebody. If you've got that much interest in your appeal, call somebody and do something. Now, if you don't do that, we have found 2 exceptions to say, even if you don't do that, you can file a writ of error coram nobis and tell us why you didn't do it in 30, you didn't do it a year in 30, and the reasons we said, I think, in Seibel and as an exception, is it's got to be pretty reasonable. I mean, the cases that we look at are pretty egregious. It's not, well, it's 6 years later, even though I waived, I'm now going to get it deported, and so I want to go back to square one.
Okay, but, Your Honor, if I could respond to that. When you have the waiver of the right to appeal and you're told that you're waiving something, and then the plea happens, and the court misinforms you about improperly informs you about immigration consequences, the lawyer is supposed to consult with you then under Flores-Ortega.
Don't you then move to vacate your plea? That's my point. I don't understand why you simply – let me finish. I don't understand why you want to appeal something where the appellate division may simply say, we're affirming, it's clear on the record, and you want to say, well, no, it's what happened off the record. They are the record. So, well, then bring a 440, and you're back in this vortex of what you want to say the lawyer did or did not do.
Well, Your Honor, he lost his right to appeal due to ineffective assistance of counsel.
Okay.
And that's the basis on which coram nobis relief can be available.
They filed a 440?
And these were meritorious issues.
Filed a 440?
Yes, he did, Your Honor.
He did file, and that was denied.
And that was denied. So
I know you've appealed
So
that.
the 440 is denied, and if the coram nobis is denied, I have a client who never had his lawyer tell him he had an issue that is meritorious, that this court has reversed on in the past, and he he suffered from ineffective assistance of counsel, and if he loses on the 440 and he loses on the quorum nobis, he is denied any relief. Evitz v. Lucy said you cannot be denied your right to appeal because you were denied your right to
Counsel,
effective
can
assistance
I
of
just
counsel.
Judge Rivera,
ask
last
the same,
question.
yes,
Go
the
ahead.
same question I asked before. Is this common, unusual, infrequent to have an attorney also sign the defendant's waiver? In your experience?
I think they sign them
They both sign it.
often, as far as
Together.
in my experience.
Okay, counsel,
Yes,
thanks.
but it was
Thank
not
you all.
meaningful here.
Thank you.